All right, hello again. This is Ben Hitchcock Cross talking to you today. I've got Buckley versus FITZSIMMONS coming to you. All right, we're going to read out Justice Stevens' opinion and talk about the limits of immunity here. That's the big highlight for right now. In this case, basically, it's a decision on what are the bounds of, in this case, prosecutorial immunity, and whether or not someone is, um, let's say, a prosecutor who is acting as an investigator is entitled to immunity. The court says no. That's the big tease there. Okay, here we go. I'm not a big fan of Justice Stevens. Don't. It's not his decisions; it's his writing. That's the issue here. And sometimes I think that they purposely give him important decisions to write unclearly to screw things up for everybody else. But hey, as this case comes to us, we have no occasion to consider whether some or all of the respondents' contacts may be protected by qualified immunity. Moreover, we make two important assumptions about the case. First, the petitioner's allegations are entirely true, and second, the alleged constitutional violations for which 1983 provides a remedy. Our statement of facts is therefore derived entirely from the petitioner's complaint and is limited to matters relevant to the respondent's claims to absolute immunity. All right, what are we talking about there? They're basically saying it's a motion to dismiss. Everything in the complaint is considered true. That's pretty standard. Now, what's the second thing here is there is a distinction between qualified immunity, which I think is the one that drives pretty much everybody up the wall, and absolute immunity. Okay, but only thing we're talking about is absolute immunity, not talking about qualified immunity. That could still be the case. Strike that and reverse it or something. Remember, qualified immunity, it comes from the Justice Scalia's theory that government officials can't know that something's illegal until they're told that by a court. Um, that seems kind of shocking to me, but that still seems shocking to me, but that's where it is. Now, absolute immunity is not a recent construction, not in the last 50 years, the 60 years. I think it's mostly it goes back in many cases to 1600s, 1400s and before. We're talking Middle Ages level of jurisprudence here, which basically means not even the king can go after a judge for the judge's decision. Okay, they're absolutely the judge is absolutely immune from his decisions, even if he makes a mistake. If he decides that the light is red and it was really green, you can't go after him for it. And that makes sense because there would be no end to litigation were we to allow that thing. Same thing is generally true of prosecutorial immunity and sovereign immunity too. They have different theories behind them, but basically the concept is all the same. You can't go to court against them. My feeling on that, which is why I think qualified immunity is so t- terrible, is that when people are immune from suit, it generally invites wrongdoing. Just think of another good. You remember when all the vaccine makers were immune from um, suit. I never thought that was a good idea for pretty much the same reasons. Petitioner commenced this action following his release from jail in DuPage County, Illinois. He had been incarcerated there for 3 years on the charges growing out of a highly publicized murder of Janine Nicarico, an 11-year-old child. Oh, I definitely remember hearing about this, not in 1988, but hearing about this case some years before. The complaint named 17 defendants, including the county, the sheriff, his deputies, 2 expert witnesses, the estate of a third, and the 5 respondents, I think that we're talking about here, that might go under the principle of going overboard. But you can see why he might have been a little bit upset. Respondent FITZSIMMONS was the duly elected DuPage County's state attorney from the time of the Nicorico murder through the December of 1984, when he was succeeded by Respondent Ryan, who had defeated him in a Republican primary election. Respondent Knight was an assistant state attorney under FITZSIMMONS and served as special prosecutor on the Nicorico case under Ryan. Respondents Callander, who came into office with Ryan, and King were assistant prosecutors. The theory of the petitioner's case is that in order to obtain an indictment on the case that had gendered extensive publicity and intense emotions in the community, the prosecutors fabricated false evidence, and that in order to gain votes, FITZSIMMONS made false statements about a petitioner in a press conference announcing his arrest and indictment 12 days before the primary election. Petitioner claims that respondents' misconduct created a highly prejudicial and inflamed atmosphere that seriously impaired the fairness of the judicial proceedings against an innocent man and caused him to suffer a serious loss of freedom, mental anguish, and humiliation. I could see that. The fabricated evidence related to a boot print in the door of the Nicorico home, apparently left by the killer when he kicked in the door. After 3 separate studies by experts from the DuPage County Crime Lab, the Illinois Department of Law Enforcement, and the Kansas Bureau of Identification, all of whom were unable to make a reliable connection between the print and a pair of boots that petitioner had voluntarily supplied, respondents obtained a positive, quote-unquote, identification from one Louise Robbins, an anthropologist in North Carolina who was allegedly well known for her willingness to fabricate unreliable expert testimony. Her opinion was obtained during the early stages of the investigation, which was being conducted under the joint supervision and direction of the sheriff and Respondent FITZSIMMONS, whose police officers and assistant prosecutors were performing essentially the same investigatory functions. Mark that well. Thereafter, having failed to obtain sufficient evidence to support petitioners or anyone else's arrest, respondents convened a special grand jury for the sole purpose of investigating the Nicorico case. After an 8-month investigation during which the grand jury heard the testimony of over 100 witnesses, Jesus Louise, including the boot print experts, it was still unable to return an indictment. Later, Respondent FITZSIMMONS admitted in a public statement that there was insufficient evidence to indict anyone for the murder of Nicorico, although no additional evidence was obtained in the interim. The indictment was returned in March when FITZSIMMONS held the defamatory press conference so shortly before the primary election. Petitioner was then arrested, and because he was unable to meet the $3 million bond, was held in jail. Petitioner's trial began 10 months later in January of 1985. The principal evidence against him was provided by Robbins, the North Carolina anthropologist. Because the jury was unable to reach a verdict on the charges against the petitioner, the judge declared a mistrial. Petitioner remained in prison for 2 more years, during which a third party confessed to the crime and the prosecutors prepared for his retrial. Jesus Louise. After Robbins died, however, all charges against him were dropped. He was released and filed this action. All right. You can kind of see why the estate of Robbins might be named in this suit. Jeez Louise. Okay. Again, for the purposes of this decision, all allegations made by the petitioner are assumed to be true. including that Robbins is a known evidence fabricator. We are not concerned with the petitioner's actions against the police officers, against the expert witnesses, against DuPage County. At issue here is only the action against the prosecutors who moved to dismiss based on their claim to absolute immunity for all claims except the claim against FITZSIMMONS based on his press conference. Interesting. I would interested in seeing that rationale, but also don't care. With respect to the claim based on the alleged fabrication of evidence, the district court framed the question as whether the effort to obtain a definitive boot evidence linking petitioner to the crime was in the nature of acquisition of evidence or in the nature of evaluation of evidence for the purpose of initiating the criminal process. The court concluded that it appears that it was more evaluative than acquisitive. Wow. Both petitioner and FITZSIMMONS appealed, and divided panel of the Court of Appeals for the Seventh Circuit ruled that the prosecutors had absolute immunity on both claims. Not looking good for the old Seventh. In which the Court of Appeals view damages remedies are unnecessary when courts can curtail the cost of prosecutorial blunders by cutting short the prosecution or mitigating its efforts. Thus, when out-of-court acts cause injury only to the extent a case proceeds in court, the prosecutor is entitled to absolute immunity and the defendant must look to the court in which the case pens to protect his interests. Well, what about frickin' spending 3 years in jail there, eh? By contrast, if a constitutional wrong is complete before the case begins, this is unprecedented theory to petitioner's allegations. Aha. Let's try that again. By contrast, if a constitutional wrong is complete before the case begins, the prosecutor is entitled only to qualified immunity. Applying this unprecedented theory to petitioner's allegations, the Court of Appeals concluded that neither the press conference nor the fabricated evidence caused any constitutional injury independent of the indictment and trial. Whoa. But he agreed that the district court, that FITZSIMMONS with the district court was entitled only to qualified immunity for his press statements. He noted that the majority had failed to examine the particular function that FITZSIMMONS was performing and concluded that conducting a press conference was not among the functions that entitle judges and prosecutors in the judicial branch to absolute immunity. Responding directly to the majority's reasonings, he wrote, I don't know if this is totally a fact, but I'll take it. It is true that procedures afforded in our, I don't know if I can totally do a South Chicago accent for that one, but hey, in our system of justice, give a defendant a good chance to avoid such results. Good chance like that of prejudicial publicity as excessive bail, difficulty of or inability of selecting impartial jury, and the like. These procedures reduce the cost of impropriety by a prosecutor, but I do not find that the courts have recognized their availability as sufficient reasoning for conferring immunity. And just think about that for a second. That basically means you've got enough recourse at the criminal court, you can't really go after the prosecutor after the fact. It's not going to be what the holding is here, but it just sounds, it's a little heavy-handed. I'll put it like that. We granted Buckley's petition for certiorari, vacated the judgment, and remanded the case for further proceedings in light of our intervening decision. On remand, the same panel, again divided, reaffirmed its initial decision with one modification not relevant here. The court of Appeals held that nothing in Burns undermined its initial holding that the prosecutors are absolutely immune from the normal preparatory steps, unlike the activities issued in Burns. I kind of think they passed up the chance to take the hint, is what I'm getting here. In similar fashion, the courts adhered to its conclusion that FITZSIMMONS was entitled to absolute immunity for conducting the press conference. The court recognized that the press conference bore some similarities to the conduct in Burns, and apparently that was advising the police as to the propriety of an arrest. Oh, yeah, I know that one. It did not take place in court, and it was not a part of the prosecutor's trial preparations. The difference, according to the court, the lower court that is, is that an arrest causes an injury whether or not the prosecution ensues, whereas only constitutional injury caused by the only by the press conference depends on judicial action. Judge Fairchild again dissented. He adhered to his earlier conclusion that FITZSIMMONS was entitled to only qualified immunity for the press conference, but he was also persuaded that Burns had drawn a line between conduct closely related to the judicial process and conduct in the role of administrator or investigative officer. I'm just saying, anybody, maybe possible directors. They could have said directors. Possibly, I'm just saying. And the role of administrator, comma, director, or investigative officer. I'm just saying they could have said that. I don't know. He agreed that trial preparation falls on the absolute immunity side of that line, but felt otherwise about the search for favorable evidence that might link the boot print to petitioners during a year-long pre-arrest and pre-indictment investigation, aggressively supervised by FITZSIMMONS. We granted certiorari for a second time. We now reverse. You saw it coming. You definitely saw it coming. The principles applied to determine the scope of immunity for state officials sued under 1983 are by now familiar. Section 1983 on its face admits of no defense of official immunity. It subjects to liability every person who, acting under the color of state law, commits the prohibited acts. In Tenney versus Brandhove, however, we held that Congress did not intend 1983 to abrogate immunities well grounded in history and reason. Certain immunities were so well established in 1871 when 1983 was enacted that we presume that Congress would have specifically so provided had it wished to abolish them. Although we found the immunities in 1983 that do not appear on the face of the statute, we do not have license to establish immunities from 1983 actions in the interest of what we judge to be sound public policy. Interesting. Our role, many people feel that you have. I'm just pointing that out for future reference. Our role is to interpret the intent of Congress by enacting 1983, not to make a freewheeling policy choice. Keep that in mind also for future reference. Since Tenney, we have recognized two kinds of immunity under 1983. Most public officials are only entitled to qualified immunity. Harlow versus Fitzgerald, 1982, Butts versus Economou, 1978. We're going to just pause here for a second because I want to make note of that so we can look into those later, even though there is a note here. There really is nothing like going to the source document. And once I saw this one here, I saw the Supreme Court reference, my ears perked up. I know we may be in 40 minutes for this thing, but anybody who's stuck with me at this point, to you. All right. Now, under this form of immunity, government officials are not subject to damages liability for the performance of their discretionary functions when their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Okay. In most cases, however, qualified immunity is sufficient to protect officials who are required to exercise their discretion in the related public interest and encouraging the vigorous exercise of official authority. I mean, right, but isn't that policy making? I'm just saying, why if it sounds to me like they're doing the exact thing that they said they weren't doing, but that's possibly happened before. We have recognized, however, that some officials perform special functions, which, because of their similarity to functions that would have been immune when Congress enacted 1983, deserved absolute protection from damages liability. That's an important fact there. They are not immune, by the way, from injunctions and equitable forms of relief, for example. An order stopping them from doing so. It's the money part that's the issue here. Which I wouldn't mind that so much as okay. The official seeking absolute immunity bears the burden of showing that such immunity is justified for that function in question. Now, I'm going to repeat that, but let's put on our Judge Dugan hats here while we're reading this too. The official seeking immunity absolute immunity, bears the burden of showing that such immunity is justified for the function in question. Even when we can identify a common law tradition of absolute immunity for a given function, we have considered whether, nonetheless, counsel against recognizing that same immunity in 1983 Act. It's public policy, but okay. Not surprisingly, we have been quite sparing and recognized absolute immunity for state actors in this context. I think for the reasons stated below, absolute immunity it's how to say it's not really American. It invites lawlessness. In determining whether particular actions of government officials fit within a common law tradition of absolute immunity or only the more general standard of qualified immunity, we have applied a functional approach, which looks at the nature of the function performed, not the identity of the actor who performed it. We have twice applied this approach in determining whether the functions of contemporary prosecutors are entitled to absolute immunity. God, Stevens going on. In Imler versus Packman, we held that a state prosecutor had absolute immunity for the initiation and pursuit of a criminal prosecution, including a presentation of the state's case at trial. Noting that our earlier cases had been predicated upon a considered inquiry into the immunity historically accorded the relevant official at common law and the interest behind it. We focused on that function of the prosecutor that had most often invited common law tort actions. We concluded that common law rules of immunity for prosecutors was well settled, and that the same considerations of public policy that underlined the common law rule likewise countenance absolute immunity under 1983. Those considerations supported a rule of absolute immunity for conduct of prosecutors that was intimately associated with the judicial phase of the criminal process. Well, that's an important phrase, not phase, phrase in that sentence, in that holding there, that it's true they're adding on, but their adding on is supported by good reasoning, and they have to be intimately associated with the judicial phases of the criminal process. It's the prosecutor. Obviously, there's no civil process for them. And concluding that in initiating a prosecution and in presenting the state's case, the prosecutor is immune from a civil suit for damages under 1983. We did not attempt to describe the line between a prosecutor's acts in preparing for those functions, some of which would have been absolutely immune in his acts of investigation or direction, or possibly administration, which would not. We applied the good old Imbler analysis 2 terms ago in Burns v. Reed. There, the 1983 suit challenged 2 actors by a prosecutor. 2 acts. One, giving legal advice to the police on the propriety of hypnotizing a subject and on whether probable cause existed to arrest that subject. That's interesting. And participating in the probable cause hearing. We held that only the latter was entitled to absolute immunity. All right, only participating in the probable cause hearing was entitled to absolute immunity, not the legal advice on the propriety of hypnotizing a subject or on whether probable cause existed to arrest that subject. That's hilarious. Immunity for that action under 1983 accorded with the common law absolute immunity to prosecutors and other attorneys for eliciting false or defamatory testimony from witnesses or from making false or defamatory statements during or related to judicial proceedings. Under that analysis, appearing before a judge and presenting evidence in support of a motion for a search warrant involved the prosecutorial's role as advocate for the state. Because issuance of a search warrant is a judicial act, appeared at the probable cause hearing was intimately associated with the judicial phase of the criminal process. We further decide, however, that prosecutors are not entitled to absolute immunity for their actions in giving legal advice to the police. We were unable to identify any historical or common law support for absolute immunity in the performance of this function. We also noted that any threat to the judicial process from the harassment and intimidation associated with litigation based on advice to the police was insufficient to overcome the absence of a tradition of immunity comparable to the common law immunity from malicious prosecution, which formed the basis for the decision in Imler. And besides, they're not to function as an extra lawmaker anyway. So, hey, super legislature. And though we noted that several checks other than the civil litigant prevent prosecutorial abuses in advising the police, one of the most important checks, the judicial process, will not be effective in all cases, especially when in the end the suspect is not prosecuted. In some, we held that providing legal advice to the police was not a function closely associated with the judicial process. Is this the Burns one? Is this? They specifically said that, man, they pretty much told the Seventh Circuit that it's not the case, and the Seventh Circuit said, and here we are, reversed. And this court, the Court of Appeals held that respondents are entitled to absolute immunity because these injuries suffered by petitioner occurred during a criminal proceeding. That holding is contrary to the approach we have consistently followed since Amber. I just like how Judge Stevens is talking to the Seventh Circuit. I think it's um, unusual. As we have noted, the Ambler approach focuses on the conduct for which immunity is claimed, not on the harm that the conduct may have caused or the question whether it was lawful. The location of the injury may be relevant to the question of whether a complaint has adequately alleged a cause of action for damages. It is irrelevant, however, to the question whether the conduct of a prosecutor is protected by absolute immunity. Accordingly, although the Court of Appeals reasoning may be relevant to the proper resolution of the issues that are not before us, it does not provide an acceptable basis for concluding that either the pre-indictment fabrication of evidence or the post-indictment press conference was a function protected by absolute immunity. We therefore turn to consider each of the respondents' claims of absolute immunity. I'm going to pause it right there, and we're going to do a separate part 2 on this because we're at the halfway or half hour mark here. Thanks for sticking with us. We'll keep you informed.